Imagine sitting at a table with 8 school professionals: a psychologist, a speech therapist, a teacher, an administrator, a translator who works for the school. They all know the system, and you don't. They slide a document across the table and ask you to sign, but you don't really understand it. Your English might not be perfect. You're worried about your job and the time that you're taking off to be at the school for this meeting. You're also worried about retaliation. If you complain or if you disagree, what's going to happen to your child? But most importantly, you're worried about your child. For thousands of families, especially families with limited financial resources, this is the reality of special education. And when something goes wrong in that system, this can shape a child's entire future. My name is Christine Lai, and I'm the founder of Special Education Legal Fund. And today, I want to talk about what happens when special education fails families and what legal remedies exist to restore equity for you and your child. The United States has a law called the Individuals with Disabilities Education Act, or IDEA. We've covered this law and these concepts in previous videos, but here's a quick reminder before we continue. IDEA, or the Individuals with Disabilities Education Act, guarantees every child with a disability for the right to a free and appropriate public education, or FAPE, in the least restrictive environment, or LRE, with an individualized education plan, or IEP. These 3 acronyms are the most important ones that you will learn in the entire special education process. These acronyms and the rights they represent are designed to protect families. On paper, the system is designed to protect families, but in reality, families, especially those who are under-resourced, can face enormous barriers navigating the process. Over the past 10 years, I've met thousands of families just like yours. Families like yours may struggle with things like language barriers, cultural differences, confusing terms or meetings, your concerns being ignored or minimized, a fear of retaliation against your child or your other children, and finally, a lack of knowledge about the law and your rights. These experiences, your experiences, are not isolated. They are patterns. But when we understand patterns, we can prepare for them. Special education is complicated, even for lawyers. Special education laws are their own distinct language, and special education has its own procedures, rules, and timelines to follow. And although these rights and laws are guaranteed at the federal level, rights and laws can differ between states. So understanding and knowing all that is a lot, even for lawyers. But what about parents? Now imagine trying to understand all of that in your second language. Many of the families I know have shared with me that they've had things like no interpreter at meetings, poor translation services, and IEP documents only in English. But here's the critical point. The law guarantees that you have to understand what's happening in an IEP meeting. So you are guaranteed a qualified translator at your meetings, word-for-word translation, and translated IEP documents. Yet many families don't know that these rights exist. And when you don't know your rights, you can't exercise them. IEP meetings can be intimidating. Imagine walking into a room when the entire school team is already seated at the table and you're alone. That dynamic sends a powerful message. They are the experts. They are united. But that assumption's wrong. While teachers and educators may be the experts on education, parents are the experts on their child. You're not in that room to question authority or disagree necessarily. You're in that room to represent your child's voice. Your voice is the only voice your child will ever have in those meetings. And if you remain silent, that silence becomes part of the official record. If you nod and agree when you don't agree or don't understand, that becomes part of the record. And when a child's needs are not documented or not documented properly, services can sometimes disappear and a child's needs might not be met. So one of the tools that families have is really pretty simple. Document everything, write everything down, document everything in email, create paper trails, because all of that documentation creates evidence. Many parents, obviously a lot of parents communicate with teachers verbally in the hallway and at pickup and have quick conversations as you're running in and running out of the school. But the problem with that is that verbal communication leaves no evidence. And in legal disputes, documentation is everything. So when you communicate with your school, your child's teacher, your assistant principal, the social worker, you need to send emails instead of speaking to them. Or if you do speak to them casually in the hallway or at pickup, send an email right afterwards summarizing what you spoke about while it's fresh in your mind and fresh in theirs. That way, your conversation becomes part of the record. And similarly, when you make a request, whether it's for additional support or additional evaluation or whatever it is, do it in an email. This ensures that there's a record of your request. This ensures that the request is documented. And texting before you ask is not the same as an email. Don't send text messages. Finally, keep records of every communication. A simple email creates a paper trail, and that paper trail creates accountability. Another common misperception that parents have about the special education process is that if the school says no, the conversation is over. But legally, no is often just the beginning, and you as a parent have recourse. If the school says no, that doesn't mean that your avenue is closed or that you don't have options. If a school says no to your request, you have several things that you can do. If the school is denied eligibility or services based on an evaluation that they've conducted, you are entitled to your own voice through what is known as an independent educational evaluation, or an IEE. Another avenue for remedy is to file a state complaint. This can work well if your issue impacts more than one child and might be systemic in nature. If you still have a disagreement with your school, you can also request a mediation. We've discussed mediation in other videos, but in a mediation, a state-approved special education mediator hears both sides and may present a compromise solution to both parties. Finally, for disputes that cannot be resolved through any of the previous options, parents as their right can request a due process hearing. We've covered all of these in another video, but it is important to highlight them here because a no from the school doesn't always mean the conversation is over. Families also mention a powerful fear. If I push back, if I disagree, will my child suffer consequences? Will the teacher treat them differently? Will services mysteriously disappear? This fear is particularly strong in communities where families rely heavily on school resources. But the law is clear. Retaliation against a student for parental advocacy is illegal. Yet, fear remains one of the greatest barriers to equity in special education. So it's important to know that it is illegal for the school to retaliate against you for advocating for your child. Advocacy matters. This is something we've been talking about throughout this whole series. Knowledge changes outcomes, and advocacy changes outcomes. And those two things together are powerful tools for you to get the support that you need for your child. But sometimes, no matter what you do, it's legal support that's necessary. It's pretty self-explanatory that, families with advocates or attorneys consistently receive more and better services for their children. But many families, most families, can't afford private advocates or special education attorneys. So what can I do? What are my options if I can't afford an attorney or an advocate? So first of all, in your community, you may have organizations that provide support for families with kids in special education. They can provide things like parent knowledge and advocacy courses, sliding scale advocacy services, pro bono legal support, and the parent education that I talked about earlier. There's also organizations in your community that might provide resources such as grants that will allow you to find support for your child. Or legal aid, even, through pro bono or low cost, low bono attorneys. So here, you should go online, ask a friend, seek help through your local special education PTA or your online support group. Organizations help level the playing field for families who might otherwise face the system alone. And these organizations exist to help families like yours navigate and understand a complex and confusing system. Finally, let me leave you with this thought. Special education is complicated. Special education law is even more complicated. But schools have teams of professionals and districts have lawyers on their side. You as the parent, though, have something far more powerful. You have knowledge of your child. You are your child's best expert and your child's only advocate. But with that comes the responsibility to educate yourself on your child's strengths and challenges, on your rights and the law, and on the procedures and the process of securing the support your child needs. Because when you understand all of those things, your child, your rights, and the process, you can make the system work for you. And when the system works for you, your child will thrive.